This meeting of the State of Rhode Island Board of Elections will come to order. It is 1:04 on Friday, November 4th. Madam Secretary, please read the roll.
Thank you, Madam Chair. Chairwoman Madeira.
Here.
Vice Chairman Pierce.
Here.
Member Bettenker.
Here.
Member DeSimone.
Present.
Member Johnson.
Present.
Member Scholes. Member West. Executive Director Robert Raposa.
Present.
Legal Counsel Ray McCarthy.
Present.
Thank you, Madam Chair.
Thank you, Madam Secretary. Our first order of business today is to make a motion to go into this emergency session of the board. Do we have a motion to that effect?
So, second.
Moved by Mr. DeSimone, seconded by Vice Chair Pierce, that the board shall go into emergency session. Any discussion? Hearing none. All in favor signify by saying aye.
Aye.
Those opposed? Unanimous vote of the board. Today's agenda. The board may hear an appeal filed by the Rhode Island Republican Party concerning actions taken by the Portsmouth and Bristol Boards of Canvassers to notify the public that Andrew V. Kelly withdrew from the race for State Senate in District 11. Do we have Ms. Siganki here? We do. Would you please come forward? Would you like to give us information about your request?
Certainly.
Oh, I'm sorry. Would you press the button? I was supposed to say that. I apologize.
Thank you. I have a loud enough voice. I think you shouldn't have trouble hearing me. Certainly. Yesterday, the Portsmouth Board of Canvassers met. We had presented them with an article asking them a letter, asking them to cease and desist from actually advertising and putting in legal notices into the Portsmouth Times twice that Andrew V. Kelly withdrew from the race. You know, as indicated by state law in Title 17, the only requirements that the Board of Canvassers and the only authority that they have is to actually certify signatures and make sure that somebody is on the ballot, the nomination papers. There is no mechanism in state law after the time limits that are set forth in section 17-14-15 and 17-14-13 if a candidate withdraws after this year, July 18th. If a candidate withdraws and has the number of signatures, they are on the ballot and there is nothing that they can do. What Mr. Kelly did was present a letter to the Board of Canvassers in October, on October 21st, and I believe the town clerk said she received it on October 24th. They then took it upon themselves to put a legal notice in notifying that Mr. Kelly had withdrawn from the race. This is an unprecedented action that has happened, and we objected to it. If the candidate themselves wants to make a public declaration, if they want to publicize it anywhere, that is up to them. But the Board of Canvassers does not have the authority to take it upon themselves to advertise that to the public. They had indicated yesterday that they're going to put notices up on Election Day that Mr. Kelly has withdrawn. So that was our objection, that they should not have taken any action whatsoever. Interesting enough, also, that the Board of Elections here, as we know, had already on October 15th set out mail ballots and early voting had already started. So this action that they took occurred after elections had already started. So we felt it interfered. Also, there is precedent. Interesting enough, there was a special election in 2016 with this exact same race where a gentleman by the name of Gregory Blythe, after he had gotten himself on the ballot, he withdrew, and they took no such action then to notify the public. And out of 207 ballots that were cast in that special election, Mr. Blythe got 28, which could have made a significant difference in the outcome of that race. So there is precedent that they didn't take any action this time that they did, and that is our objection. They should have just stayed out of it, and especially after the election had already started.
Okay. Do any of our members have any questions? Yes, Ms. Bettenker.
You mentioned the 2016 president. How many days before the special election did he withdraw?
So he withdrew after he was already on the ballot. He
Mhm.
actually appeared on the ballot.
Mhm. Okay.
And because he appeared on the ballot, he actually did receive votes.
Ms. Sankey, I'm wondering, is it your position that election officials don't have the authority to notify voters of information that would allow them to have an effective vote?
No, our position is that they don't have the authority. If they want to have the authority after they've been withdrawn, our position is go change the law. You know, they may feel that they have a responsibility. It really is the responsibility of the candidate to notify the public. The Board of Canvassers, their only responsibility is to make sure that they have proper signature verification and that they actually have the nominating papers. That's their role. And their role is then to run the election with the people that get themselves on the ballot.
So they
Miss-
they
no.
wouldn't have the authority to
don't have the
notify
authority.
voters that a candidate is no longer eligible because they've withdrawn from the race.
Right. So if somebody had died on October 21st, the Board of Canvassers does not even have the authority to put a death notice up in the election
Do you have
if they
any
had died.
case law that suggests that?
There is, no, there have been instances throughout the country where someone has died and they've actually won the election. Once you get on the ballot, if you did not withdraw within the time period that's set under Title 17, you are on the ballot, and the Board of Elections currently, under current law, has no authority to interfere with it.
But our U.S. Supreme Court has found that actions may be taken to ensure that votes are actually effective, right?
Well, but effective for a dead person. You can vote for whoever qualifies to be on the ballot is on the ballot. And particularly, they took this action after voting had already started. So if their theory is we wanted to inform the public, they actually waited too late to inform the public because voting had already begun.
Okay. But you're familiar with the state law, for example, even Bonanno versus DeStefano, where the courts have recognized that the state board, for example, has plenary authority to make sure that an election is run efficiently, even if it is to take actions that are not exactly specified by statute.
Yes, true. They are to take actions in the running of the election, but under state law right now, there is nothing.
It's silent.
It
It's
is silent. It
but-
is silent to this. You actually have in your Title 17, it actually specifies the process for withdrawal. And Mr. Kelly had
Up to
until
a certain date.
he had up to a certain date. He had until July 18th to effectively withdraw. It does not stop any other candidate that was in the race with Mr. Kelly and Mr. Kelly himself from identifying that I'm not going to be in here, I'm not withdrawing. He could have taken an ad out. He could stand outside the polls within 50
But you're
feet.
saying that
and
the
telling-
election
But
officials
the
cannot.
election officials do not currently have that authority to interfere.
So
in a
the
way.
question for this board is whether or not, in their view, the actions taken by the election board first are legally authorized, and two, if they're reasonable in order to assist the voter in having an efficient ballot. So to make sure they weren't voting for someone who's no longer on the ballot.
Well, he's on the ballot. That's the problem. He
No longer
is
running, I
on the
should say.
ballot. He is absolutely
Right.
on the ballot.
But he's no
It
longer running.
becomes a slippery slope. At what point does the government that does not have the authority then take it upon themselves to say, vote for this person, vote for that person? He legally got himself on the ballot with the required signatures and then did not do anything. He actually, at a public forum, got up and said, I'm not running. So he already informed the public, but the government should not have stepped in when they don't have the authority. Again, he had plenty of opportunity to do that himself.
I mean, the government actually authorizes or acknowledges a person is eligible and.
That's right.
And
And
If that
sets time
person-
limits. Sets time limits within the statute 17-14-13.
to make
that
sure
he-
that the ballot is published
Right.
properly.
And once it's published, it's you're on the ballot whether
So that
you
that is the
decide
question
not
then,
to.
whether
And
after
if-
that date, a local board as an election official is frozen and unable to take any action to make sure that voters have an informed mind as to who actually remains on the ballot.
Right, and the point then becomes, at what point do we not follow the law as it's currently set? You have a mechanism. There is no mechanism now. And if you're going to allow this, then we get a slippery slope. When do we stop this? You know, the day people come in for elections, then we say, oh, by the way, Joe, he just sent us a letter this morning. He's not running. At what point? You set time limits in the statute so that everybody understands the process. And the process was not followed. I think if we have identified an issue here, then the remedy, the remedy is then to go to the General Assembly and say, hey, we have an issue that came up. We don't have enough time. Can we, as a board, can the Board of Canvassers then take this upon themselves to do this? Currently, right now, there is no mechanism, and that is our
Let
objection.
me just ask you just a hypothetical, just so I understand, and maybe the board, it'll help frame this in their own minds. Assume for a second that there was a special election held in a community, and assume further that the special election had two eligible candidates who were on the ballot, and finally assume that both withdrew from the ballot effectively with a notarized letters saying that they were off the ballot. In your view, is the election process frozen and still has to go through the process even though both candidates are no
They're
longer?
on the ballot. They qualified for the ballot. And interesting enough, the case that I brought up, or the example in 2016, that the gentleman withdrew, and he withdrew because he was a federal contractor and had to because of the Hatch Act. That is a very viable reason to withdraw. But the Board of Canvassers at that point in Portsmouth, that happened 7 years ago, did not take out a legal notice. That gentleman did receive 28 ballots. I will say the Republican did win. Maybe that Republican would not have won if the BOC was allowed to take an action and put a notice in there. But that's the exact same scenario that happened here. They took no action. The gentleman was on, and maybe we have identified an issue here, but the issue, you do not have the authority as the Board of Canvassers to change the law. And the law currently says you have to withdraw, you're on the ballot.
Do you have a question, Mrs. Johnson?
Yeah, I have a question. Just trying to get this straight in my head. You keep saying, Ms. Yankee, that they are not authorized because of the way the law reads, but there isn't a law. The law doesn't read that they are not authorized. So I'm trying to, Ray, you said, felt it as their responsibility. And I agree that the law should be clearer and that we
Right.
should take that up. But I'm trying to understand, they didn't do anything illegal and maybe felt, I don't know, I'm not inferring, but because of this last case that this man who was deceased got 28 votes.
He wasn't deceased, he just withdrew.
Oh, he withdrew. I thought you said someone died. Sorry.
I don't think he's
But that
deceased.
he withdrew, which was his choice. I understand. And when this gentleman withdrew, the ballots were already printed
And the same scenario.
and the same scenario played out. So I'm just trying to wrap my brain around if they felt it was their
Right.
responsibility to make sure that the voter had clear information that this man, I understand he had a
Yes.
forum, not everyone attends public
Right.
forums. So when you're saying not authorized.
So there's a difference between what the Board of Canvassers thinks is their responsibility and what they have the power to do. So they may feel it was their responsibility to say something, but they do not have that power. The power that the Board of Canvassers has is very limited in what they can do.
No, I
They don't
understand
even
that.
certify the results in a Senate race. They don't do
I
that.
understand.
So it's, responsibility versus your power. What power did the General Assembly gave them?
Hmm.
My general counsel just walked in.
Okay.
Come on up,
I-
Dan. This is
Denise,
Dan
you wanted
Riley.
to-
He's our general
Did you have a
counsel.
question you wanted to ask? Let's hear from you.
Oh, did you say that the ads have already been circulated?
The ads have already been circulated once on November 3rd and once on October 27th.
In the legal notices section of the paper?
Legal notice section, it's an exact replica of the ballot.
Okay, were there any mailings or anything of that nature done?
Not that I'm
you're
aware of.
Okay. So let me ask you this, the ads have already appeared.
So the ads have already
So-
appeared, but the issue becomes, I'm sorry, I don't mean to interrupt. The issue becomes on election day. All indications are that that is the most popular day for people to vote. There is the mail ballots, there is the early voting, but a substantial number of people will be voting in person on election day. And as indicated by the Board of Canvassers, they want to put up notices that Mr. Kelly has withdrawn.
Okay, so you're not looking for us to do anything plenary, you're just looking for us to essentially prevent the board from doing that on
Anything
election day.
further? Yes.
And I think also for the early election, right? I mean, for tomorrow, let's see.
Yes,
today
for the
would be
remainder of the early,
Yeah.
I mean, we have
Not much
one day
time
left.
Yeah,
Effective
yeah.
immediately, to stop them from doing anything, effective immediately.
Any other questions of any of the board members? Okay, thank you.
Thank you.
We'd like to hear now from the boards of canvassers from the towns. First, we'll hear from Portsmouth. Representatives from Portsmouth are here and would like to tell us what took place. Please identify yourselves
Can you make sure you turn on your mic?
and your microphone on. Jacob will be sure of that. It's tricky.
Okay, thank you very much.
Thank you. Yes,
Good afternoon. Jacqueline Schultz, Registrar of Voters, Portsmouth, Campson, Florida.
okay,
Nancy Zitka, Chair, Portsmouth Board of Canvassers.
thank you.
Kevin Gavin, Portsmouth Town Solicitor, representing. the board.
Thank you, sir. Thank you all. Well, who is going to be the spokesperson?
Since I was the only one there in 2016, I might as well start.
Very good. Let's hear from you.
And in 2016, we did have a special election for Senate District 11. And candidate Blythe notified me of his removal via a phone call at the time. He did not send in a notarized document. So it was not presented to the board. Everything had already been printed, and there was very little we could do about it. I had contacted Tiverton as well as Bristol at that time. They had more experience. This was only my second or third election, and I never had done a special election before. So I consulted with those who were there at the time, who were also running the election for Senate District 11, because it included those communities as well. As far as this current situation is concerned, I received an email from my town administrator that was forwarded to me from Ms. Cienki. My email was incorrect, so I would not have received it had it
I'm
not.
going to interrupt you just for a second. It just occurred to me, we should swear in, this is not going to be fact information. We should swear in the witness.
Oh, okay. I didn't believe we had to do that for this, but if you say we
Yeah.
should, then we
Any,
should.
any evidence. Ms. Yankee was providing argument, but this looks like it's going to be
This is
factual presentation.
Okay. So would you please be sworn? Okay. Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Very good. Continue, please.
After receiving the email, I forwarded it to whoever I needed to, with my board members, the solicitors, to find out, because it did say cease and desist. And at that time, we had already run an ad. Our advertising is determined when we do our financials, our budget for the year. We know what has to go in. And I sent in the notice of the election along with what we call, it's not a factual ballot. It looks similar to a ballot. I did the exact same thing in 2018. It includes what the precinct is. It tells about the ballot questions, but it does not have the ballot questions on it. So it is modified by the Board of Canvassers to assist voters to understanding that, and it even had a note that not all Portsmouth ballots are the same, that they really do have to pay attention, because not every candidate that is in that ad is going to be on their ballot when they go to cast their ballot. So this is an assistance that we do to try and clarify things for voters who are often very confused about why a particular candidate is not on their ballot. So when I sent that in, unfortunately, it did go in at the same time as the legal notice. So it did have a legal notice notification on it, but it was scheduled to run for 2 weeks. Because we have early voting now, it's important for voters to have information earlier than what the schedule was in the past. The legal notice was removed on the second notice, but the notation still remained the same. And again, we also ran the notice of the election. We scheduled a meeting to address Ms. Cianki's concerns. At that meeting, she gave her arguments, and I have the unapproved minutes that are circulating with the board members right now before I post anything on to the Secretary of State's website. And at that meeting, Mark Cantor, made a motion that the Portsmouth Board of Canvassers would continue to communicate with the electorate of the resignation of Mr. Kelly. We received, actually, I do want to let you know, I did not receive that letter until October 24th. Mr. Kelly came to my counter with the letter that I timestamped at that time, 8 something in the morning. So we did not take any action until this candidate had formally indicated that he was no longer on the ballot. And at that time, I notified the Board of Elections, the Department of State, Melissa. I sent them all copies of this letter showing of his withdrawal.
So just to be clear, the difference between this instance and the one in 2016, that candidate did not formally send you a letter of withdrawal that was notarized by anyone.
Right.
Okay,
That is correct.
So that is a significant difference there. Any members have any questions of the registrar from Portsmouth?
Yes, I do.
Mr. West?
So to ask that the ad that you submitted is just, it's not the actual ballot itself. It's just one that has all the voting districts in the town of Portsmouth. And everyone is included in that ad.
What it does is I took the format that I get from 2018. This is something, it's a standard practice that we do for every general election. We will print the contents of the ballots, because in 2014, we printed the actual ballots in a flyer. And voters were very confused because there were 7 or 8 different ballots. They did not know what precinct they belonged to. They did not know which candidates were going to appear, because we had, at that time, 3 representative districts. So our canvassing office was getting phone calls saying, why isn't Jay Edwards on my ballot? You know, I want to vote for that candidate, or I want to vote for somebody else. So what we do now is we print out the list of all of the candidates and what the questions are. In it, I indicate on the list of questions that I refer to the handbook, saying if you want any information about these questions, you have to go to the handbook. And then when I go to the representative districts, I indicate which precincts. If you live in precinct 2701, you're going to see this candidate on your ballot. If you live in precinct 2702, 3 or 4, you're going to see this candidate. If you live in the others, and that's as an aid to help voters understand the differences in the ballot.
So we're not, this is not an official, it's not an official
It's not the official
ballot,
ballot. We
but
don't
what it
pretend
is, it's-
that
it's
it's, and
informational.
it says information, ballot information. That was the title. It's not, here is your ballot for Portsmouth.
Okay, any other questions, Mr. West?
Not
That's-
just-
At this point, do you have a question, Mr. DeSimone?
Not for.
Anyone else have any questions? Anything you'd like to add? The other folks who are here? This town solicitor, did you wish
I
to
would
speak?
just comment that it's been recognized there's no specific provision that prohibits what the board did, and what they did was provide notification to the voters of true and accurate fact that Mr. Kelly did in fact file formal withdrawal notarized, and it's a public record. So essentially what the complainant is asking this board to essentially impose a gag order on the local board from informing the voters of true and accurate information. I think, and it's not, there's no specific provision that prohibits that, and I think it would certainly be contrary to the spirit of the election laws to impose a gag order on the local board.
Okay,
And could we
Comments,
have a,
questions?
we should mark, Madam Chair, a copy of the letter of October, the one that is, that you
Kelly's
received
letter?
on October 24, as, and that can be marked as the board's Exhibit
Exhibit
1.
1.
I have one question,
Mrs.
Madam
Johnson,
Chair.
go ahead.
Is it Ms. Schultz that you, just a question of what prompted you to post this legal notice? I understand it's
It's
true.
standard. It's, and
That the
unfortunately, it
candidate
was listed
withdrew.
as a legal notice because it was sent in with the notice of the election,
Okay.
which is a legal notice. The second time it ran, it was removed. I asked because it was too late when I received the initial complaint. It's a weekly publication
Okay.
that we advertise in. It has to be in by a specific time on noon.
Yep.
But I was able to remove the legal notice from the second time that it ran, and it did not run. I asked that it not be run on the same page. The first time it was side by side. If you notice on the second time, it was separated. There was so we tried to clarify it in that.
So it was on a
sense.
different page.
It was on a different page.
And just one more question. As of now, as of today, your plan for Election Day is to, in some way, shape, or form, notify the voters at the polls of
We
this
have-
withdrawal?
We have small cards that say ballot note, Senate District 11 race, candidate Andrew B. Kelly withdrew.
Okay.
And that is in each poll booth.
Okay.
And that is, it's the plan that we have them delivered to the polling locations on Election Day and ask the poll workers to put those in each one of those booths, which is standard practice for a change in any kind of election. It's
Okay.
not unusual.
Yeah,
So-
thank you.
So this is a board action that was taken, that was sanctioned by your legal counsel.
This was the plan originally to do, and it had been discussed with everyone, with the Board of Elections as well. And this was the suggestion that was made to notify to notify voters that the candidate had formally withdrawn.
But you're saying that the chair asked, did the board take action? Did your local board take action approving this?
Yesterday, they did.
So that was the
That- it
first
was-
time?
It was yesterday, yes. Initially, before, it was a suggestion made, and it's the exact same actions that other communities have.
Well, it looks like the board is now, your local board has now taken action, which is good and it shows their approval. But in the future, any information that relates to a ballot, especially a message or communication going to a voter with respect to a candidate, should be part of a public meeting, public vote, and a public decision by that board.
Thank you, Ray. Yes,
Um,
Mr. DeSimone.
And so the information card that you were going to place into each of the booths, You said, you noticed the board, you noticed our staff about that as well?
Yes, I notified them, and actually, they looked at
Okay.
the ad that went in the paper. It wasn't a legal notice that was sent to
So,
them.
so just for council, so Ray, I echo your concern. I mean, the first concern I would have is that I'm not disparaging anything that they did, but I
Right.
think there should have been a board vote.
Mhm.
But be that as it may, it appears that the board ratified that by their vote anyway.
I agree.
I guess what my question would be, Ray, so if we're to take the position that you don't have the authority to notice someone, and the local board doesn't have the authority to clarify an election matter, then if we look at the statutes on withdrawal, are they to tell the candidate you can't withdraw because you didn't withdraw in time?
See, I don't read it the same way as Ms. Cienki does. I mean, we do have a statute directly on point, which has a direct deadline. And that is designed, in my judgment, to make sure that the ballot is as well, as accurate as possible. When circumstances take place after that date, the General Assembly hasn't said, and no other information shall go out to the voter. It doesn't say anything like that at all.
So there's no prohibition
There's
legally
no-
against what they
It's,
did.
it's silent. So Ms. Yankee's saying in that silence, you can't act. In the balance, though, we have to remember that our US Supreme Court has recognized for decades that there is with that right to vote, that constitutional right, there is a right to be informed. And other courts have looked at that and said, when circumstances on a ballot change and the elected official makes a communication that is apolitical, so it does not in any way take a support for any particular issue or candidate, that, and I'm sure there are exceptions, that if it is a reasonable communication, it will be allowed because it effectuates the voter's ability to have an effective vote. So that's what it comes down to. Here, everything I've seen, and it's up to the board, obviously, but there doesn't seem to be anything here except the fact that they prematurely made the communication, although it's been ratified by the local board. The message itself seems to be quite neutral, which is, here's the fact, this person has withdrawn, period.
So Ray, the other situation is, if the Supreme Court's giving authority, and we'll for sake of simplicity saying for boards of elections or state boards or state election officials to clarify an election, doesn't it follow that would go down to the local canvassers as well?
They run the local elections. Very few of those things come to this level unless it's involving a state office holder. So it would follow that in order to make sure that the voter has information that is relevant to the ballot, that would be effectuated by the local board, not by the state board.
Well, I mean, I think you could tell us how to proceed at this point, Ray, but I think first of all, I think factually, we need to make a determination that the ads that went in were certainly not partisan. They were only informational in nature.
So we should, do we have copies
if
of
we
those
have those, we could-
communications?
yeah.
We should mark those as an exhibit. Oh, okay. This is the paper? All right. Good, I'm glad you did.
Are those the 2 weeks of ads?
Yes. This is the first.
Okay. So mark these as exhibits 2 and 3.
2 and 3.
And just for the registrar again, so that ad simply recites the fact that he withdrew.
Yes.
Were there any other communications that were sent out or that,
No, the only thing that we did was mark him as withdrawn.
Patty, can
On
the
that list,
board would
and-
like to see it, actually, I didn't realize. I think they're the same.
And we placed the notices in the early voting booths.
I was going to ask that
And-
question. So
And,
they were there in
My
the
next
voting.
question was gonna be those notices, right? If we could, do you have copies of those notices by any chance?
No, I don't. I'm sorry.
Do you know what exactly, well, I think you've already said,
Yeah,
but
it
just so
says
they're clear,
ballot
exactly what,
note, Senate District 11, candidate Andrew B. Kelly withdrew.
Just
I'm
that,
sorry, withdrawn?
withdrew.
And that's all that notice says?
That's all it says.
I mean, I'm certainly willing to accept that.
Do we, at this point, we've heard from these folks and I think we probably had no further questions at this point, would you say?
I mean, I don't.
Mr. Pierce, do you have
I
anything you
don't
want to ask?
know.
Mr. West, you're all set. So do we have to hear from the other board or at this point we
no,
have the information
if,
we need?
if Ms. Yankee may want to examine someone, I don't know, that's her right. But in this instance, if the information that will be provided by Bristol will be cumulative, there's no need to hear it. If it's different, then I guess it would be,
I guess my only concern, Ray, would be what notices is Bristol putting out and what notices
good
they already
point.
put in the
Yeah.
newspaper?
That's a good
then we
point.
should get those answers.
If we could.
Okay.
Those
So,
would be my only concerns. Because I mean, again, everything they did was just, as far as I'm concerned, it was just informational, but.
Could we
okay,
hear
thank
from,
you.
from
Yes,
Bristol?
let's hear from Bristol, please. Thank you. So would you identify yourselves for our record, please?
Yes, Melissa Cadero, I'm the canvassing clerk in Bristol.
Yes.
Marie Knappman, Board of Canvassers, Bristol.
Okay, we need to swear you in. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Very good. Okay, so would we like to ask the same questions, Lou, about the actual notice, or do you have anything you'd
Yeah, I
like
mean,
to
did you do a newspaper notice as well?
I did. I did not do a legal ad. I did just an election notice. It says, please be advised that candidate Andrew B. Kelly has withdrawn his candidacy for Senate District 11 at the general election for 2022
Okay, and that appeared in,
on October 27th and November 3rd.
and that was the, and again, we don't have a copy of that ad, but you're testifying that that's what the ad
That's
said.
what the ad said.
And that was in the local Bristol
That was
paper.
in the local Bristol paper twice.
And are you also putting something in?
The
The
exact same
booths?
publication as of right now is in our booths. Yes.
Okay. And you also spoke to our state election staff with regard to putting that in the booth?
Correct.
I guess the last question I have, Ray, is did you have a canvassers board meeting?
So
On this
I
issue.
did not receive any correspondence from Ms. Sadesky until November 3rd at 4:40 PM.
Okay,
So that was after the publications have already gone into the paper. There's no way for me to pull anything. And no, as of right now, I have not had a meeting with my board.
okay,
We do have one of the members present, however.
right.
Yeah.
I mean, I don't know how we handle that part of it, right?
I
But
mean, I think, for better or worse, I mean, I know the timing is critical, but in my judgment, despite the very good intentions of staff that work for these local boards under difficult circumstances,
Yeah.
there are some things that cannot be done by the staff themselves, or they have to be done by the board as a board.
so I guess my suggestion would be that at whenever your next canvassers meeting is, that at least, at the very least, they ratify that action. And that's just from your end. I mean, I'm not your solicitor, but
Right.
I would talk to your solicitor.
And I
about
think under the circumstances, Mr. DeSimone, this board could take a vote at least to approve these messages if you find them to be reasonable under these circumstances.
If I may say one thing,
Yeah, sure.
I just want to say for the record that for what I did, I just assumed that public information was supposed to be made public to the public, and that's why I put that on there. Mr. Kelly, I got presented that withdrawal, saying that he withdrew, and I felt an obligation that voters should know that.
No
public
one, no one
information
questions
should
that.
be-
No, no,
I totally understand that. Mhm.
Any other questions?
I just think that's,
Mr.
thinking
West?
again, since this is something else that's come up that maybe, again, after the elections, this is something we should look at and see whether or not we need to put.
Mr. Reposer, are you hearing Mr. West? He was making a very good
whether it
suggestion.
would Be something that the board approves of, whether it be a regulation or an actual uh, law or whatever, maybe regulation that when someone withdraws, that the Board of Canvassers has the ability or the authority to inform the public of the withdrawal of this candidate after the fact, after all the ballots have been printed and
Something to look at perhaps for the next election is what Mr. West is
I agree.
suggesting.
yes, I mean,
Yeah,
there's nothing we can do right now for this election, but I think
Right,
going down the road,
I agree.
For 2024.
correct. Mr.
Uh,
Pierce, do you have something?
I think we should focus on the July date. And the importance of that date is to permit the start of the preparation of ballots so that they can be distributed in an adequate time for all that has to be done in order to run an election. So I see that date as the reason for it being in the statute. In this particular case, I think we have an issue of the responsibility of keeping the electorate informed as to the status of the issues that they're going to be faced with at the polls. And it seems to me that keeping the public informed as to whether or not a person wishes to withdraw as a candidate and has indicated his or her intention that he or she were doing that is an important piece of information for the electorate to have at hand. So I see that in this particular case, assuming appropriate authority by the local boards of canvassers with respect to any notice in that regard, so that we're sure that it is in no way partisan in any way, I think that this was the appropriate thing to be done in this particular case.
I mean, I certainly agree with the commissioner's stand on that. I mean,
Yes.
the other issue is I don't see it as much different from a board of canvassers saying to everyone, remember, there's a second sheet on the ballot. There's a reverse side on the ballot.
There are two
There's
sheets, yes.
the referenda are on a separate page. The referenda are on 2 pages. I don't know that it's that far removed from that. Obviously, it's something different, but this ad looks, all it says is candidate withdrawn. I mean,
Yeah.
it's-
Correct. Any other questions of the Bristol officials? No? Thank you both very much
Thank
for
you.
coming.
So Ray, are we in line for a motion with respect to the appeal that's been filed before us?
Yeah, and I think that is the way it will be framed. It's an appeal. The actions have been taken by the local boards. You've already, so yes, it would be with respect to the appeal itself, whether you're allowing it or dismissing it.
I mean, I would move to dismiss the appeal. And I would also urge the Bristol board to have the actions of the staff ratified at some point. But I mean, certainly there was no malice here. And I don't think it's a situation where they're prohibited. But that's just one person on the
So
board. but
Mr.
that'd be my
DeSimone
vote.
has made a motion to dismiss the appeal. Do we have any second to that motion?
I will second that based on the comments I made earlier. I think the importance here is that the electorate be kept as well informed as possible about the situations with respect they're going to vote.
Thank you, Ms. Pierce. So we have a motion and a second to dismiss the appeal. Any discussion by members of the board? Any questions? Hearing none, we shall vote. All in favor signify by saying aye.
Aye.
Those opposed? It's a unanimous vote of this board. Thank you. Thank you all very much for coming as well. We appreciate that. Do we have a motion to adjourn the meeting? Moved by Mrs. Johnson. Do we have a second? Seconded by Mr. West. All in favor signify by saying aye.
Aye.
Opposed? We are adjourned at 1:47.